Hey everyone, in life we build. We build homes, we build businesses, we build families, and sometimes we believe that by putting things in place, properties, bank accounts, structures, we can control the future. But life doesn't always go as planned. This is the story of a devoted Singapore father who built everything for his daughter, and how a court case 20 years in the making revealed something unexpected. Let's unpack the dramatic High Court decision of Peter Kwee and Lai Seng Kwoon, a legal tale of trust, intention, and what truly belongs to whom. Peter Kwee is a motoring tycoon. Over the decades, he built his empire and poured his success into one purpose: his family. Among his children was Karen Kwee. She lived in properties bought by her father, worked in companies owned by him, and even her day-to-day expenses were paid by him. But here's where things get interesting. Peter Kwee didn't keep those properties under his own name. Instead, he bought those properties under Karen's name. 2 in Singapore, 1 in Australia, and 2 in Canada. A total of 5 properties. Why? Peter Kwee says that it was for business strategy, risk management, and wealth planning. Peter Kwee said that he and his daughter had a name placing agreement, that the properties were under Karen's name but really belonged to him. Fast forward to 2022. Karen is declared bankrupt. Now, under Singapore law, when someone is bankrupt, all the assets in their name go to the trustee in bankruptcy to repay their debts. So Peter goes to court. He sues Mr. Lai Seng Kwoon, the trustee of Karen's bankruptcy estate, claiming, hey, these 5 properties may be in Karen's name, but I paid for them. They are mine. The court had to answer 2 burning legal questions. Who really owns the 5 properties and the 3 bank accounts? Was there a trust between Peter and Karen, or did Peter give those properties to his daughter? Now, here's where trust law steps in. Peter claimed he never gave the properties to Karen. He was just placing them in her name for convenience. So he relied on 2 legal ideas: resulting trusts, which means I paid for everything, so it's mine, and common intention constructive trust, meaning we had a common intention and she holds it on trust for me. But Mr. Lai, the bankruptcy trustee, pointed to another legal principle: the presumption of advancement. In simple terms, when a parent gives something to a child, it's presumed to be a gift, unless the parent proves otherwise. You can watch one of my earlier videos on the presumption of advancement. So did Peter Kwee really intend to keep the properties, or had he given them away to Karen without realizing it? Peter Kwee argued, I paid for everything, either directly or through my company. Even if money came from a joint account or a company I controlled, it was still mine. Peter also argued that putting the properties under Karen's name was just part of his estate planning. He said, I told her from the start, these properties are still mine while I'm alive. She couldn't even withdraw money from the joint accounts without my permission. He called it the name placing agreement. Mr. Lai, the bankruptcy trustee, shot back. Peter Kwee never documented anything. No written agreements, no proof that he didn't mean to give the properties to Karen. Karen acted like the true owner. She signed an option to purchase in relation to one of the Singapore properties without even telling Peter Kwee, her father. If Peter really owned the properties, why didn't he object earlier? Why wait until bankruptcy? The trustee said, this looks like a classic case of a father giving generously to his daughter and now trying to take it back because of the bankruptcy. So what did the High Court decide? Justice Philip Jeyaretnam took a deep dive into the family's conduct, their conversations, their relationships, and ultimately ruled against Peter. He found that, yes, Peter funded the purchases of the properties, but funding alone doesn't decide ownership. He had donative intent, meaning he wanted to give the properties to his daughter. The judge believed that Peter intended for Karen to own the properties eventually. Why? Because Peter told her in Mandarin, after I die, these properties are yours. He didn't behave like a real owner. For example, when Karen tried to sell the King's Drive property in 2020, Peter didn't immediately step in to claim ownership. In fact, he only lodged the caveat in 2022 after she was already in financial trouble. The control Peter exercised wasn't unusual. He was a patriarch. Of course, he advised his daughter, but that doesn't mean he still owned the properties. And as for the bank accounts, the money largely came from rental income from the properties. Since the properties belonged to Karen, so did the rental income. The court dismissed Peter Kwee's lawsuit and his counterclaim, and he was ordered to pay legal costs over $190,000. This case is a powerful reminder that even the deepest love cannot override the law. Peter Kwee's intentions may have been noble. He worked hard, built an empire, raised his children, but he never wrote things down, never made things clear. And when trouble came, ambiguity became his enemy. The court wasn't judging his heart. It was judging his intentions and actions through the lens of evidence. Now let's take a step back. Isn't there something beautifully fragile in this story? A father thought he could manage everything, control everything, keep everything in place. But as life teaches us, the things we hold onto the tightest are often the ones that slip through our fingers. Let go. Let clarity replace control. Let love guide legal planning, not just emotion. If you are a parent helping your child with property, take this as a lesson. Don't just rely on trust. Use legal documents and make your intentions clear. Thanks for joining me in this case summary. I'll see you in the next video.